Thank you for your courtesy. You may be seated. We will open our record. We're here in case number FECR 051688, State of Iowa versus Kristin Ramsey. Ms. Ramsey is here today in person with her counsels of record, Mr. Parrish, Mr. Brandon Brown, Ms. Westhoff Gentry. The state likewise appears here today through their counsel of record, the county attorney, Mr. Schultz, the assistant county attorney, Ms. Loving, and Mr. Brown, who appears here as well from the Iowa Attorney General's office. Ladies and gentlemen, we have a large crowd here today, and so I want to start by saying that we are here today to conduct a hearing, and the outcome of this hearing, the court recognizes, is important to all concerned. As presiding judge, it's my duty today to ensure that this hearing is conducted with dignity and respect, so that each side, when they leave this courtroom, can say after the hearing has been held that a fair hearing was held. Therefore, let me say at the outset to the members of the audience, though this is a public courtroom and a public hearing, justice dictates that there be no disruption from anybody here that could affect the outcome or which could prejudice either side. Therefore, to ensure a fair hearing, I'm going to put the following rules of decorum in place. Number one, upon entering or leaving the courtroom, please do so quietly so as not to interfere with these proceedings. If you have a seat, please remain seated unless you are entering or leaving the courtroom. Do not converse in audible tones while court is in session so that you can be heard by the court or the parties, because that would distract from these proceedings here today. No outbursts by any person will be tolerated, and if there are any outbursts, they will be dealt with immediately by the court, and any offending party will be removed from the courtroom. I think the easiest way to convey what I mean is that I expect you all to conduct yourself in the same manner that you would want people to conduct themselves if you were a party to this case. Now, I will not repeat this going forward, and I expect to know that you will each conduct yourself accordingly. With that, let's proceed to the hearing that is before the court today. Before we came into open court, the defendant filed a written arraignment, which the court has reviewed, and I will enter a not guilty plea as set forth in the written arraignment in the record. The defendant has waived her right to a speedy trial. So the first item of business will be to pick a trial date. And so, Mr. Schultz, I'll turn to you first. What do you propose as a trial date?
Thank you, Your Honor. Your Honor, we expect discovery to be lengthy in this matter. We believe that it'll take the defense, we expect some time to be able to get through that. And so I don't know if we can go off the record, Your Honor, and talk to defense and see if we can come up with a mutual date.
Very well. If that's acceptable to the parties, when we take a recess, we'll see if we can come up with a date. Mr. Parrish, is that acceptable to you and your client?
Yes, Your Honor, that is acceptable. Thank you.
Very well. Then we'll handle that before we conclude today. And after I hear the input of the parties, we'll set a trial date and the next court proceeding in this case. There are two other matters the court needs to hear and decide. The first I want to address is the defendant's motion, which has been filed, I believe, on April the 8th. That was the resistance was filed on April 8th. The original motion was filed on March the 19th. The motion is the defense motion to quash the search warrant and for a protective order. Mr. Parrish, I understand that you were the one who's going to be arguing that motion. Is that right, sir?
That is correct, Your Honor.
And Mr. Parrish, I appreciate the courtesy, but you can be seated, sir.
Okay, thank you.
And Mr. Parrish, I would turn it over to you for any record you want to make in support of your motion.
Judge, with that motion, as the court is aware, we filed an exhibit from an expert witness. Mr. Schultz and I had some initial discussions about that. It's the phone, Your Honor, which we did not identify, but it is the phone that was taken in 2026. In that phone, according to our expert's opinion, I think Iowa Forensics is the company.
And Your Honor, I would object, just for the fact that we're going to be discussing an exhibit that was provided past the deadline. The court had done an original order stating that the parties needed to submit exhibits by the 8th. The state didn't see this exhibit till today, and so I'd ask that we strike the exhibit from the hearing today, Your Honor.
Your response, Mr. Parrish?
Well, I thought our off-the-record discussion and the prior discussion, I can limit my argument solely to the prior discussion that Mr. Schultz and I have had about it. Your Honor, it's your discretion as to whether or not you think this exhibit will give you some guidance in the decision. I think it's a common sense type of exhibit. He doesn't go into any details about the specific phone. So I don't think that's the issue, but I think we all have common sense that your phone might have what you call personal information, such as communications with counsel. Second of all, it would have information related to medical records. I get all of my medical records on my portal, on my phone, and I think most people do nowadays. So it's that type of information that we believe should be restricted. Specifically addressing the issue of whether or not it should be late or not, I'm not sure the state has filed any exhibits. Mr. Schultz told me as late as last night, they did not plan to file any exhibits. The exhibits.
Mr. Parrish, I'm sorry to interrupt you, but let me just deal with this exhibit issue first, and we'll give you a chance to make your argument. So, Mr. Parrish, just so I understand, are you offering the exhibit or not?
Yes, we believe the exhibit should be presented. I think the court in its discretion to see whether or not it is informative to the court as to what type of information might be private. But I'm sure with the number of cases I've handled in this area, I can make a professional statement. But we think the exhibit ought to be accepted by the court. The state has a copy of it. They can review it. They can determine whether or not they see something that's objectionable about it. We would leave it at that, Judge.
Mr. Schultz, just so I understand, you're not asking to continue the hearing. You're just asking to exclude the exhibit. Is that correct?
Yes, Your Honor.
And so tell me what the reason is for the exclusion.
Well, Your Honor, the court had entered an order that we exchange exhibits prior to the hearing. I believe they needed to be exchanged and filed by Wednesday of this week at 4:30. That was not done in this case. This exhibit was filed this morning. It doesn't provide us an opportunity to really respond to it other than to verbally, I guess, get into it. We don't have our own expert now to rebut anything that Mr. Parrish is stating. I'd ask the court to strike it, and if not, then give it limited weight.
So I guess that's why I asked the question about the continuance. You're not asking for additional time to hire your own expert to counter the exhibit, is that correct?
Correct, Your Honor. We're not asking for continuance.
Very well. Well, the court hasn't seen the exhibit, so Mr. Parrish, I'm going to reserve ruling as to whether or not I consider the exhibit because I haven't had a chance to review it, but I will admit it into evidence. The question is going to become whether or not the court gives consideration to it. So with that understanding, Exhibit A is admitted.
I appreciate that, Judge. Now, I would say not arguing the exhibit, what it goes to, we have to first of all determine what type of phone our client had in their possession that was seized. Mr. Schultz and I had a lengthy conversation in his office about what information may be private and what information might be subject to their access. I will say this, we have no issue with the access to the information that the state is seeking, because I think we discussed whether or not we would be actually asking for what's called a protective order with regard to privacy matters, or whether or not there would be information that the state feels might be important. So I would say, Judge, it's really a common sense application to this. I've discussed how in the past judges have handled this matter, which they've said, this is certain information in federal court is handled by, they will do what they call a taint team. That taint team will look at that information. They will decide, well, is it attorney-client privilege? Is it medical records coming from a certain doctor? Is it her son's medical records that would be irrelevant to anything? Or their conversation, all the privileged areas such as spousal privilege, that is protected. We don't think the state in their initial warrant, and I believe Mr. Schultz has properly indicated, they have not actually issued the warrant yet, and I get that, because I believe he indicated he was going to hold up until you would give us some direction as to how that should be handled. I will tell you from my experience how we've handled it before, either with a tape team, which is just automatic in federal court. In state court, a few state court judges have said, okay, let an independent examiner have it as opposed to the DCI. My last experience was with the DCI, where the DCI had actually seized the phone, asked the judge for a warrant, and there was private information on that phone, and the judge assigned an independent forensic examiner to look at it, to exclude. Under what's called the Cellbrite software download, in that instance, they download everything. They just put it on a software, everything goes into it. So that means that with regard to Ms. Ramsey's phone, all her private information would go to the government without any of the protected order. So all we're saying is, I think we can work out an agreement with them where if they wanted to, we could say, okay, this is excluded. But we would want our expert there watching that download to make sure that private information is excluded. Clearly, they have a right to some of the information, and that might be on it, may be relevant to them. I think they're entitled to get it. But a private protected information under the protected area that is statutory in Iowa, they're not entitled to have it without a specific request to you.
Does that conclude your argument, Mr.
It does,
Parrish?
Your Honor. Thank you.
Very well. Mr. Schultz.
Thank you, Your Honor. Your Honor, just for the record to be clear, search warrants are secret, and they're secret for a reason. But I will clarify, because I want to clarify the record. Search warrant was originally done, which allowed us to seize electronics, including the phone of the defendant. Another search warrant was issued, but not executed, because we are waiting to see what this court is going to do. And so I want to be clear on that point. It's not something we would normally argue about, because these are usually secret. But in this case, since it's being discussed today, I want to be clear on that. You know, the reason we have search warrants is to protect the rights of citizens under the Fourth Amendment of the Constitution and Article 1, Section 8 of the Iowa Constitution. It protects us from unlawful seizures. It also protects our right to privacy. But the reason we have a search warrant is to balance those rights with the interest that the state has in order to collect evidence when a crime is committed. And so, to me, when I look at the rules of criminal procedure, there's no rule that allows the court to create boundaries on a search warrant or after the fact. The court actually, there's a process in place under the rules that allows the court to look at the evidence that's presented, weight the statements from law enforcement, from probable cause, and then make a determination on whether to sign the warrant or not. And that is the balance that's struck under the law to protect the rights of citizens, but also protect the interest of the state in looking for evidence and investigating evidence of a crime. to me, what the defense is asking is that if I were to show up to a house with a search warrant that's been lawfully entered, that a defendant and their attorney can stand at the door and say, wait, you can't search the house. You have to, you can only search this room or that room or that room, and that's not what's in the warrant. The way the law works, and has been working for hundreds of years, is it provides protection for the defense, for the defendant, if there's something illegally searched or obtained, to have a search, sorry, having a brain fart, Your Honor, to file a motion suppress and to suppress the evidence. And that is what, in this case, should happen. The defense shouldn't be able to stop the state from going in. If they go into the house and find evidence that's relevant, that's not in the search warrant, they're required to go back to the court and apply for another search warrant. And it'd be no different in the case of a cell phone. If we were to go through the cell phone and find something that wasn't in the parameters that the court signed in the search warrant, we would be required to come back to the court with another search warrant to search for the items that are relevant. If something is privileged, then the court will make that determination after the fact through a motion to suppress, saying that the state's not allowed to use that evidence. And that there is no case law, there is no rules in criminal procedure that allow for the court to put boundaries after the search warrant has been signed. And so, in this case, Your Honor, we're asking the court to allow us to execute the search warrant and any future search warrant that we may ask for in the future, to allow us to do the investigation that we are allowed to do under the law. Thank you, Your Honor.
Mr. Schultz, what's your response to the defense's argument that perhaps this phone contains attorney-client privilege? While I agree that's an evidentiary privilege, but still, if there was attorney-client privilege on this device, you wouldn't be asking for that, would you?
We would not be, and it's not, and it wouldn't be inside the search warrant. And so, if the police officers were to run into that, they would skip over it because it's not part of the search warrant, Your Honor. And that's how it's done in every other case in the state, and that's how it's always been done. We are creating a legal fiction, in my opinion, to allow defense to attack the investigation before we even know. And it's not allowed under federal rules, and it's not allowed under our state rules.
Thank you, Mr. Schultz. Is there anything else you'd like to make part of the record regarding this motion?
No, Your Honor.
And Mr. Parrish, since it's your motion, I'll give you the last word on the motion.
Thank you, Your Honor. I refer the state to Raleigh v. California.
Hey, Mr. Parrish, I appreciate courtesy.
Sorry. It's just an old habit I can't break, Judge. I appreciate it. Yes, I would refer the state to Raleigh v. California, which was the first United States Supreme Court case to deal with it. And then all these cases have come down since that time. I think your question was spot on. What if there's attorney-client? So does the state then have a right to go in, pull up that attorney-client stuff, let the DCI look at it, and then says, oh man, look what we got. But also we got another unique factor in this case. It's 15 years old, Judge. What stuff they're looking for is 2026. So part of our issue is going to be, well, where's the data from the phone from 2011, first of all? Did you go in there and spoil it? We don't know yet because they haven't given us that information. But also in 2026, they're asking for information. It's kind of like the other day when they are digging in the backyard in 2026 related to information from 2011. So Riley v. California is kind of the seminal case where the United States Supreme Court say, hey, phones are just like rooms, as has been eloquently described by Mr. Schultz. So what the Supreme Court has said, you got to be careful. You got to go get a warrant because they used to search them without warrants, as you probably know, Your Honor. But now that you have these cell phones, you just can't go into them. Every case, Judge, I have been involved in federal court where that issue has come up, they have a taint team. Now, I know this is not federal court. This is state court. In state court, every motion we file for a protective order says this. It's not super complicated. It just says, look, if you get information that is private, and you can't see it if it's a Cellbrite download, that's why they won't talk about it, because they know the Cellbrite download downloads everything. They don't have any eyes to see attorney-client privilege, medical records, stuff like that. That's why it's so important, Your Honor, for you to take a look at that. And if necessary, Mr. Schultz feels he needs an expert, we're happy to debate it, but we're happy to give him everything he's entitled to. We just don't want to give him our client's medical records, her conversation with her spouse, her conversation with, if it's a priest or minister. They're not entitled to get it. Now, there may be certain circumstances that they could get this under, but not on some general warrants that we're going to go on a search of her cell phone. I wouldn't want people to have my cell phone because it has every medical record I've ever had on it. And that's the same thing that Ms. Ramsey is entitled to protect. So I think it's an easy solution, Your Honor. That's all I would say.
Your Honor, may I be heard?
Briefly, go ahead.
I would just ask the court to look at our brief that we filed.
I have.
And I do want to point out that these privileges are testimonial privileges.
I understand, counsel, your position.
Thank you, Your Honor.
Mr. Parrish, anything else?
No, Your Honor. Thank you so much.
Mr. Parrish, I would like the benefit of having you to submit a proposed language with, a proposed order, with language that you propose. That doesn't mean I'm going to grant it, but I want to see the parameters of what you're requesting specifically. And counsel, once he does that, you certainly can file any proposed response that you'd like, okay?
Thank you, Judge.
Very well.
Thank you, Your Honor.
Okay, the next matter of business today is the last matter of business, and that's the defendant's motion for bond review. Mr. Brown, I understand you're going to be presenting the evidence on that. Is that correct?
Yes, Your Honor. Argument. We don't have witnesses, but yes.
I'm sorry.
It's all right.
I forgot there was two Mr. Browns. I apologize.
Oh, I'm sorry. I thought you were.
I saw who you were looking at, but
We are not related.
Fair enough.
So,
Mr. Brandon Brown, excuse me. If you are ready to present evidence, you may do so.
Your Honor, before we present evidence, do you have a problem if we deal with the issue, first of all, of the nature of the offense, and then in my opening to the court, and then Mr. Brown then would deal with the witnesses? If you want me to deal with it afterwards, I'm happy to do that.
Yeah, here's what I'd like to hear. I'd like to hear all the evidence to be offered. Sound like the state does not have any evidence. Then I'd like to hear the arguments of counsel regarding what you believe the court should do, okay?
Thank you, Your Honor. And you don't mind us splitting that portion of it?
No.
Because we won't get into the nature of the offense with the witnesses. Thank you, Your Honor. Appreciate that.
Mr. Brandon Brown.
thank you, Your Honor. May it please the court. The court is well aware of the factors it must consider when...
Mr. Brown, I'm sorry, maybe I wasn't clear. I'd like to hear the evidence first.
Yeah, I'm just going to give you a brief summary of what we'll expect from our witnesses.
I don't need to hear that. Just
Okay.
present the evidence.
Fair enough. We would call our first witness then, Kristin Williamson, Your Honor.
Okay.
Well, do you want witnesses separated, Your Honor? They have not asked for it. Do you want witnesses?
That's up to the parties.
no, that's fine.
Are you okay?
Yeah, we're
All
good.
right.
Ma'am, if you come forward, when you're ready, face me and raise your right hand. I'll swear you in. Do you solemnly swear or affirm that the testimony you're about to provide will be the truth, the whole truth, and nothing but the truth? Please be seated. Ma'am, that microphone in front of you, you can move your chair to get a little closer. If you could make sure to speak into it so we can all hear you, that would be appreciated by the court. Counsel, when you're ready.
Thank you, Your Honor. Good morning, ma'am. Would you mind stating your name, first and last, and spell them for the record?
Kristin Williamson, KristinWilliamson.
Ms. Williamson, do you reside here in the state of Iowa?
I do.
Where do you live?
Osceola.
And do you reside in Osceola with anyone?
My husband.
Okay.
Okay. Sorry. Okay.
Are you currently employed?
Yes.
In terms of the length of employment, how long have you been gainfully employed, ma'am?
Since I was 16.
And do you have any criminal history?
No.
Can you tell the court how you know Kristin Ramsey?
Chrissy and I went to school together. She came in 6th grade.
Okay. And what school did you go to?
Woodward Granger.
And can you tell the court generally what size of class would you have at Woodward Granger?
We had a very small class. I would say 20 to 25.
In a small class like that, I suspect that the circle of friends is all pretty close. Is that fair to say?
Very much so.
And having a small class size like that, not only do you get to know your classmates as friends, but I suspect you also get to know their family as well. Is that correct?
Yes,
Do you know Chrissy's family?
I do.
Can you tell the court a little bit about Chrissy's family?
They're good people. Throughout school, you know, we always did different things. We had slumber parties, that sort of thing. And going over to Chrissy's house was always fun. It felt like home. She had several cats and a dog, Duncan. Her siblings were great. Chris and Julie were great. Good people,
Did you always feel welcome in their home?
always. It felt like home,
You always felt safe at their home?
always.
Now, I understand you currently live in Osceola, is that correct?
I do,
And up till Chrissy's time of arrest, she was in Woodward. Is that your understanding?
right.
Now, you had told the court that you had went to school with Chrissy until graduation. Have you kept in contact with Chrissy at all since graduation?
Through social media, her mom, you know, through town people.
Okay.
Just,
But while you were in school, would you agree that you knew her through middle school, junior high, and high school, those critical periods where character development and personality development were occurring?
yes.
Can you tell the court a little bit about Chrissy's character that she exhibited as you knew her and as she developed it through those important developmental years?
She was a sweet person from day one, 6th grade. Very good, caring, compassionate, selfless person. She would do anything for anyone.
Did she have a lot of friends?
She did. Everyone liked her.
She got along with everybody, is that correct?
She did.
What kind of activities would you do with Chrissy while you knew her in school?
School things, of course. I think we were 7th grade basketball cheerleaders. I think we were only 2 at that time. And then in senior year, we were on the competition squad.
Tell the court a little bit about that.
It was a group of 10 girls, and Chrissy was a co-captain. That was probably the funnest 2 years of my life. We did a lot of things for that group. We qualified for a national cheerleading championship in Anaheim, California. We all went, and parents went, my parents went, had a great time, great memories.
Okay. In terms of how she acted outside of school, did you ever see any behavioral problems?
No,
How about in school? Did you observe any behavioral problems?
no,
Was Chrissy a positive person?
always.
What would you say about her in terms of her compassion?
She was always caring, willing to help, no matter what, no matter who it was. Just always there, wanting to talk if you needed to talk. She'd make you laugh if you needed to laugh.
Go ahead.
Just a good person.
Did she
genuine.
take any leadership positions at any activities in school?
Right, she was the co-captain of cheerleading, and let's see, that's all I can think of right off the top of my head right at the moment, but a very well-respected person all throughout high school. Everybody wanted to be around her, liked her.
And her reputation through school?
Excellent.
Okay. What was she like in terms of trying to attain popularity? Did you observe anything along those lines?
She didn't try to be popular, she just was, because everybody liked her. She was a good person to be around.
Okay. Did you ever see any evidence of bad character being exhibited by Chrissy?
No.
How was her temperament as you knew her throughout school?
She is probably the most even-tempered person I know. I have never seen this girl be angry, mad, or upset. Ever. Ever.
If I were to ask you, what was the worst thing that you ever saw Chrissy do, what would you say?
Well, traditionally, in high school, as cheerleaders of the football team, we may have TP'd the football players' houses. That is the worst I've ever seen.
Okay. Was Chrissy a helpful person?
Always.
Did she demonstrate empathy for and care about people throughout school?
Yes.
Was she responsible?
Yes.
How so?
Well, she showed up every day, for one. She was very loyal. You could count on her. She always did her schoolwork, of course. She was always there for cheerleading practice. Always, you could just depend on her.
Good attendance?
Good attendance.
She was invested in all of her activities?
Yep.
She took everything she did seriously?
Yes.
Okay. You said you knew her family, you spent time with her family. How would you describe her family in terms of their character and their
Very similar. Chris and Julie are awesome people, always have been. Very loving family, welcoming again, and well-liked in the community. Very upstanding citizens.
Okay. Now you are aware Chrissy's been charged with the murder in the first degree. Is that right?
I am.
We've talked about that. You've read about that. You're aware of that?
Yes.
And even knowing that, you are here to offer your insight and your opinions about Chrissy to the court because you know that we're asking for her bond to be reduced. Is that correct?
Yes.
Okay. Based on the characteristics and the values that you saw Chrissy develop and exhibit during middle school, junior high, and high school, do you think that Chrissy poses any reasonable danger to the community?
No.
Based on the characteristics and the values that you saw Chrissy develop and exhibit through middle school, junior high, and high school, do you feel that she would in any way flee or not show up for her required court appearances?
No.
Okay. I have no other questions, Your Honor.
Cross-examination.
Thank you. Is it Ms. Williamson, is that correct?
Yes, that's correct.
We've never met before, correct?
I don't think so.
All right. You live in Osceola currently, is that right?
I do.
And how long have you lived there?
Oh, 23 years.
Okay. And what's your employment? What specifically do you do?
I work for the state of Iowa, and I schedule hearings, send out orders, file things.
Do you work for the court system or the clerk's office?
Yes.
Okay. Ms. Williamson, your day-to-day involvement with the defendant, Kristin Ramsey, was whenever you were much younger. Would that be true?
That is true.
Okay, so so middle school would have been like the early to mid 1980s. Would that be right?
Yeah.
And what year did you graduate from high school?
91.
Okay, and would the defendant have been in your class at Woodward?
Yes.
So she would have graduated in 91?
Yes.
And then your lives would have separated at that point. Would that be true?
True.
So you didn't have any regular contact with her after 1991. Would that be true?
Just through, the community. My mom still lives there. My sister still lives there. And
So
I still have friends there.
So other people would tell you about things that the defendant might be doing, things of that, correct?
Sure.
She wouldn't have consulted you on large life matters. Would that be true?
No.
So anything that she would have been doing with her business, with real estate, she doesn't consult you about that,
No.
correctly?
No.
You don't have any conversation with her about business dealings, correct?
No.
Or her financial condition?
No.
Nothing along those lines?
No.
Has she ever asked you for a loan or asked you for any money or anything of that nature?
No.
All right. Prior to Kristin Ramsey being charged with murder in the first degree, when would have been the last time you would have had any communication with her?
Probably shortly after graduation, I would presume. I cannot think when the last time was, but I kept track of her. I think we kept track of each other. We just may not have spoke.
So if things would have changed with regard to her demeanor, her personality, things that she would have been involved with, you would not have had any direct knowledge of that, correct?
No.
Are you aware of any drug use that Kristin Ramsey has engaged in?
No.
Anything that would relate to methamphetamine or marijuana?
No.
Would it surprise you if those drugs were in her presence?
Absolutely.
What about firearms? Did you ever see or know Kristin Ramsey to use a firearm?
No.
Would it surprise you if there's information that she had used a firearm in the past?
Yes.
Even if it would have been legally, would that be true?
Yeah, I would be surprised.
Thank you very much. I have no further questions.
Any redirect, counsel?
Just briefly, just so we're clear, the physical distance is why you no longer have any more contact with Chrissy. Is that fair to say?
Correct.
There was no falling out or anything like that?
No. We just live separate lives.
No further questions. Thanks, Judge.
Ms. Williamson, you can return to your chair. Thank you. Please call your next witness.
Thank you, Your Honor. We would call Jean Grell.
Mr. Grell, sir, if you come forward, I'll swear you in when you're ready, sir. If you would please raise your right hand. Sir, do you solemnly swear or affirm that the testimony you're about to provide to be the truth, the whole truth, and nothing but the truth?
Yes, sir, I do.
Please be seated. Mr. Grell, if you could likewise move your chair close to the microphone so you can speak into it so we can all be sure to hear you, I'd appreciate it. Counsel, when you're ready.
Thank you, Your Honor. Will you please state your first and last name and spell them for the record, sir?
Yes, my given name is Eugene. That's E-U-G-E-N-E. The last name is spelled G-R-E-L-L.
And Mr. Grell, my understanding is that you are somewhat hearing impaired. Is that correct?
That is correct.
Okay. If there's at any point that I'm speaking too loud or not loud enough, would you please let me know?
I certainly will.
Okay. Do you currently live here in the state of Iowa?
Yes, I do.
And what town do you reside in?
I live in Woodward.
Okay. Are you currently employed, sir?
No, I am officially retired.
In terms of past employment, can you outline for the court what you've done over the course of your life?
Yes, I have a BA from Augustana University in Sioux Falls in education. I have an MS from Creighton University in Omaha in school administration.
And then in terms of employment?
My first job was in Southwest Iowa, and I was a teacher for 7 years with special needs children while I worked on my degree over at Creighton in school administration. Then I became a middle school principal, which you only do when you're young, I found out. I became unhappy with education at that stage in life, and so I opened my own restaurant in a small town in Southwest Iowa. My son, my wife, and I ran it. Then I was approached by a convenience store chain owned by the Kroger Corporation over in Omaha to come to work for them because I had both business experience and the educational background. And so I became a professional trainer, working with, first of all, store-level employees. Then I moved up to building them an assistant manager training program and finally doing seminars for the managers at the store level. When Kroger downsized in the late 1980s, I knew my job was going to go away. That's usually what happens when corporations downsize. And so I started looking for a job. I took a job down in Falls City, Nebraska, for only 1 year as their elementary principal. I guess the only way to put it is my wife and I could never get used to the Nebraska culture. And so I applied for a job and took a job up in Northwest Iowa, not too far from where I originally grew up. And in that school district, I was initially their elementary principal. Then when the school combined with the school district to the west of us, I became both the elementary principal and their curriculum coordinator.
Okay. And then, go ahead.
Yeah. I've done lots of things in my life. My wife was life flighted from Omaha, from Spencer, Iowa, to Omaha, and had 2 different types of transplants done. And so I retired at the young age of 53 to care for her the rest of her life. She lived 13 more years. And during that time, whenever she was medically stable, I then took part-time jobs. So I have worked for CPAs, a local firm, during their tax season. When they were done with me, then I would move over and worked for both ACE and Hy-Vee as their garden center coordinator, manager, whatever you want to call it. I also worked for the county here in the auditor's office for the last time, this last past election, because first of all, my hearing is getting questionable, and because my age is advancing. So with them, I worked again during the entire election process, getting things set up. In fact, I'll head over and make sure they're online to do what they're supposed to be doing in the upcoming election in June.
How about volunteering? Are you doing volunteering as well?
Yes, my son tells me I have retired at least 12 times. He's probably a little shy on that. It's probably more than that. I have done social ministry for Mount Olivet Lutheran Church over in Perry, which is where I go to church and where one of the Ramsey members also attends. Social ministry involved a lot of things. We operate a bedding service out of the church, especially when the packing plant was still there. Tons of people being pulled in by Tyson who come with nothing. And so the church purchases bedding that they can check out. Then we started a co-op program with the Optimist Club in town. They now purchase the children's beds, and the church purchases the adult beds. And then as part of that, I just went out to the other churches in the area, and so we did socks and underwear drives for the school. We did coat drives in the fall. I started a furniture bank and a donated storage space. Those types of activities in social ministry. I also help at the local Woodward Food Pantry after having worked at the Perry Food Pantry prior. I also did something called Harvest for the Hungry, where I went out through all of northern Dallas County and found people who had garden produce or field produce, and I delivered that to the food pantry. So.
And then, while being in Woodward, did you get to know Kristin Ramsey and her family, Mr. Grell?
I'm sorry, could you say that again?
I said, yeah, during your time in Woodward, did you get to know Kristin Ramsey and her family?
Yes, sir. When I and my wife moved to Woodward to be closer to our grandchildren who were living over in Granger, we moved into the lot where Chrissy's and Toby's house would have been, prior to the tornado that came through in 2005, a builder had built a spec house there, and we bought that home. So we were actually neighbors across the street to them.
And what was the first occasion you had to meet Chrissy and her family?
From memory, it was that she and Toby came over and introduced themselves, as well as Toby's parents, because we were right across the street. Kind of wanted to know who the new folks in town were. So.
And for the record, Toby is Chrissy's husband, is that correct?
That's correct. Sorry, I should have explained.
That's okay. And then Toby's parents also are your neighbors across the street, is that right?
His mom still lives there. His dad's across town now. But yeah.
Okay. So how long then have you known Chrissy and her family?
We moved in October of 2007, so give or take about 18 years.
And during that roughly 18-year period of time, you've been their neighbor right across the street?
That is correct, except for this final year, because of the rising cost of property taxes and insurance on my home. I simply decided to move into an apartment. So this last year, I haven't been their neighbor.
Are you still in Woodward?
Oh, yes.
And when you were neighbors with the Ramseys for roughly 18 years, and I know it could be weather dependent, but how long or how often would you see the family?
Again, very seasonally in the summertime, all the time, because I am in retirement a gardener, so I'm either out in my garden or in my yard. And so they would be out caring for their lawn or things on the house. The dogs would be out running the lot. I sat out and read a great deal in the front yard. I don't know that for a fact that whether they did or did not see me, but when my wife died in 2015, I often used what some of the members of my support group for grief suggested, and that's what's called cold therapy, where you actually, she died in March, and so because of all of the flashbacks that I had caring for her and all the things that had to be done to her, I would go out and sit on the front steps, which faces their house, and in the cold, with just basically a t-shirt on, it makes you slow down and takes your mind off of all these things that keep coming back. So,
would you have conversations with Chrissy and Toby and Tanner throughout those years?
I call that across the fence. I have to say I'm very fortunate to have moved into the best of small-town Iowa neighborhood. Just briefly, some examples. There's an older woman behind me who used to come over and swipe rhubarb out of my garden, and I caught up with her one day, was not upset, but told her I would bring it over to her house from that point on, and she was insistent. No, she's somewhere between 80 and 90 years old, and she was insistent she was going to use her cane and get over there and get it. And I said, well, you help yourself. And then whenever her kids would show up, I would go over and say things to them like, well, your mom's been over stealing rhubarb again. So the neighbor directly behind me, her parents are older. She lived with them. Dad had Alzheimer's, and so she would ask me to come over and watch them while she ran for medication or groceries, that kind of thing. The neighbor next to her, which is also behind me, scraped the alley, which the city generally did not get done in time for me to get out when it was snowy to get over to my job at the CPA office.
What about the Ramsey family? It sounds like there was a lot of neighborly things being done. What about Chrissy or her family? What kind of neighborly things would they do?
Well, I guess the one that would stick out most in my mind, I mean, we talked across the street, not the fence, but that sticks out in my mind is Chrissy would often send Tanner, her son over to scrape my front parking and the sidewalk up to my house. And I, of course, would come out with money and he would refuse it, which gave me an indication of what she was like. I'm an older person, not taking advantage of. And so my workaround for that was, I knew when Tanner's birthday was, because we had lived beside him for so long, and so I'd stuff the money into a birthday card, and of course he got it, and Chrissy couldn't say a thing, so.
What kind of observations did you make about Chrissy and her character based on your experience of being her next door across the street neighbor for 18 years?
I would have to use words like humble, kind, caring, very mild-mannered person, meek, and very devoted to her family.
She raised a good son, Tanner, didn't she?
Oh my gosh.
So good that he dates your granddaughter now, right?
That's correct.
When did the two start dating?
When they reached high school, but Tanner and I have known each other a lot longer than that. I would have to tell you that this is very unusual for a young male, at least in my experience as an educator. Tanner would come up and sit beside me at activities where he was not directly involved and sit and just talk. And usually young men, from my experience, once they reach that middle school, high school age, you're the last thing that they want to have contact with. So,
You would attend his sporting events, though?
yes, I attend all sporting events, all activities, but it would include things like, National Honor Society, those kinds of things too. Yeah, I'm a pretty loud person, and so I sit up in the stands, and usually nobody wants to sit in front of me. And a lot of the parents at least in our district, will sit out in the outfield or they'll stand along the fences at football season because they want to be closer to the action. During halftime or during in between innings, I would usually go out and give them a bad time, for lack of a better word, and stand and talk to them, and they would be saying, "Oh, we heard what you yelled at the referee," or whatever. So,
Chrissy would be at all the baseball games, is that correct?
oh, both parents very, very supportive. Yes.
She'd be at all the football games, is that correct?
Yes.
Would you see Toby and Chrissy being involved at Halloween, handing out candy and the like in the neighborhood?
Yeah, he used to dress up. We were one of only a couple houses on that end of the street, and he'd be out there, giving the little ones a bad time, and then sending them over to my direction. So,
Let me ask you, did you ever observe or notice any disturbances coming from the Ramsey home?
no. And back then I had my hearing, so no, I've never heard anything of that kind of nature.
Okay, and you know that Chrissy has been charged with first-degree murder, is that right?
I certainly do.
And again, you know that you're here to offer your insight and experiences and opinions based on what you observed of Chrissy over the 18 years you've lived next to her, because we've asked the court to reduce her bond, is that right?
Yes, I do understand that.
Now, if the court were to grant our request and reduce her bond, do you believe, or would you have any reservations about Chrissy returning to your town, into the neighborhood where you lived for 18 years?
The best way to answer that is my grandchildren grew up in my son and daughter-in-law's house, and their babysitters were I and my wife. And as two educators, you don't get by with much. And if I knew something was going on in that home, she would not have been allowed to be there. I would have gone to my son and his wife, and they would have said no.
Okay. Do you believe, based on your experiences and your observations of Chrissy over the last 18 years, that she poses a risk of harm to your community?
I'd have to say she's the last person in that town that I would think would be involved.
Okay, no other questions.
Cross-examination.
Thank you, Judge. Mr. Grell, good afternoon. I don't think we've ever met, is that correct?
We have never met, sir.
All right. You are a neighbor to the Ramseys, is that right?
That was
Or was?
for the first 17 years, yes.
Okay, when did you cease being a neighbor to the Ramseys?
I moved into the apartment in May of last year, so almost a year now.
Okay, and whenever you lived near the Ramseys, that would have been across the street, is that correct?
Directly across the street, that's correct.
And your interactions with them would have been normally as a neighbor, most of it like out in the yard, see them on the street, things of that nature, is that correct?
Yeah, around town, whatever it may be, or the sporting events or activities at school, correct?
So most, if not all of your interactions with Kristin Ramsey would have been in a public setting, would that be true?
That's pretty much true.
You've never been in the Ramseys' home?
I think only once, when I moved, Tanner had taken an apartment off campus at the University of Iowa and needed a bed, and I was trying to get rid of a lot of stuff, and so I helped them get the bed over to their house. That's about the only time I've been inside.
All right, so you've never been, other than that, you've never been in their home, correct?
That's correct.
Are you aware of any drugs in the Ramsey home?
No, I've never seen any evidence of that, and I've worked with a lot of people in social
I
ministry.
understand, I'm just asking what you observed.
Yeah,
Okay?
no,
And you wouldn't have observed any methamphetamine, wouldn't have observed any marijuana in their home,
no,
correct? Never used, or never observed either one of them using drugs, is that correct?
that's correct.
Would it surprise you if those types of drugs were found in their home?
Yeah, it would surprise me based on, my interactions.
And are you aware that a number of firearms were in the Ramsey home?
I had no idea they had guns.
If you knew that Kristin Ramsey committed a murder, if you knew that, would your opinion of her change?
I'm going to object, Your Honor. That's not in evidence.
This is a character witness.
The objection is overruled. The witness can answer. It's a hypothetical.
Would you restate it for me,
If
please?
you knew that Kristin Ramsey committed a murder, would that change your opinion?
No, what I would have to say is,
That's all I'm asking is whether or not that would change your opinion. You
Yeah.
said no.
You didn't have a chance to finish.
It's a yes or no question.
All right, hang on. The witness can answer the question. Go ahead, sir.
what I would say is, as with many of the neighbors from all over western Iowa, they would continue to be neighbors for life. It would not matter to me.
That's all.
Any redirect, counsel?
None, Your Honor. Thanks.
Mr. Grell, sir, you can return to your chair.
Thank you.
Please call your next witness.
Thank you, Your Honor. We would call Julie Boyles.
Very well. You come forward, ma'am. When you're ready, I will swear you in, just like I've sworn the other people. So when you're ready, face me and raise your right hand. Do you solemnly swear or affirm that the testimony you're about to provide to be the truth, the whole truth, and nothing but the truth? Yes. Thank you. Please be seated. Because it appears you may be soft-spoken, I want to make sure you position that microphone, and if you need to move your chair, please do so we can all be sure to hear you, okay?
Yes, sir. Thank you.
When you're ready, counsel.
Thank you, Your Honor. Ma'am, will you please state your first and last name and spell them for the record?
Julie Boyles, Julie Boyles. Okay. I'm sorry. This chair doesn't want to move too well. How's that? Is that better? Okay.
And Ms. Boyles, you are Chrissy's mother, correct?
Yes.
Where do you presently live?
Johnston?
And are you married?
Yes.
How long have you been married, ma'am?
Since 1983.
And who is your husband?
Chris?
And Chris has been Chrissy's stepfather since 1983, then, is that correct?
Correct.
Can you tell us a little bit about your husband?
He's a pretty calm individual. He doesn't get riled up, doesn't make judgments. He's a lot like my dad.
What did he do for employment, ma'am?
He worked for the post office for 30 years.
Okay. Did Mr. Boyles serve in the military?
Yes.
Do you know where he served?
He was in the National Guard for 7 years.
Okay. Did your husband serve overseas?
Yes.
When would that have been?
He was in the Gulf War, so when that was.
How long was he overseas, do you recall?
From December of 90 to May of 91.
Okay. And Chris took pride in being Chrissy's stepfather. Would you agree?
Yeah.
It sounds like when Chris was serving overseas, there was some concerns he may not make Chrissy's high school graduation.
That's right.
What happened?
Chris had a friend in his unit. It was based out of Perry. It was a transportation unit in Perry. And Ronnie had gotten sent home earlier. And he also was a pilot. And when Chris's transportation unit got into stateside and got to Missouri, Ronnie said he would go down and get Chris and fly him home to make sure he was home for Chrissy's graduation. But the weather wasn't good, so he drove down to get him and got him back home about an hour before graduation.
Chrissy and Chris have been close their lives, haven't they?
Yeah.
Are you employed, ma'am?
No, I'm retired.
What did you do prior to retirement?
I was the insurance and billing manager for a counseling clinic in Urbandale.
Okay. How long did you do that?
33 years.
Any criminal history?
No.
How about Chris, your husband? Any criminal history?
No.
Does Chrissy have siblings?
She has a brother, an older brother, a younger sister. She has a bonus brother and a bonus sister.
Where do those folks live, ma'am?
One brother lives in Madrid, one brother lives in Pleasantville, sister lives in Harrisonburg, Virginia, and the other sister lives in Minburn.
Has some of her friends and family turned out to support her for the bond review hearing?
Yeah, several.
Are they present behind her?
Yes.
Okay. Including Tanner, her son?
Yes.
Chris, your husband?
Yeah.
Toby, her husband?
Yeah.
Tell us a little bit about Toby.
Toby's been in our home prior to he and Chrissy dating because he was friends with our two sons. And so it wasn't till Toby was a senior that, and Chrissy was a freshman, that they started dating.
And so Chrissy would have dated Toby her freshman year? Is that right?
They went to his senior prom. She was a freshman.
Have they been together ever since?
Yes.
High school sweethearts?
Yes.
And Toby's family, do you know Toby's family?
Oh, yeah. Yeah, of course.
Does Toby's family live in and around the same community where Chrissy and Toby live in Woodward?
Yeah, Jody lives just a block away with her family, and Shannon and Dan live in Granger with their family.
Okay. One more person we haven't mentioned who is here today is Chrissy's grandfather. Is that correct?
Mm-hmm. Yeah.
What's his name?
Malin Conaway.
And that's your father.
Malin, M-A-H-L-O-N, Conaway, C-O-N-A-W-A-Y.
And he's here, right?
Yep, it's right out there.
How old is Chrissy's grandfather?
Dad will be 101 in August.
Can you tell the court a little bit about your father? He's lived a rather extraordinary life. Would you agree?
Yeah, he's pretty extraordinary. He's a very proud World War II veteran. He's received several medals. He's the 2024 Iowa veteran, VFW Veteran of the Year. He's received the French Legion of Honor. We have to call him Sir, he's so well loved in Perry and so well known in Perry because of his service.
The French Medal of Honor, or the French Legion of Honor, is that the highest military honor that French?
Yes, it is.
What did he receive that for? Do you know?
For his help with liberating France.
Okay. What did your father do after he returned?
After Dad came home from the war, he drove for Rouen Transport. I'm thinking Dad drove for 30 years. He's hard of hearing. He would correct me if he could hear me probably. But yeah, he was one of the first few that worked for John Rouen.
As Chrissy grew up in the home, you had pets around, is that right?
Oh yeah, we have a lot.
Okay. Your family members would come and go and play with her?
Yeah.
How would you describe her upbringing?
It was just a loving home. We care about each other. We're very close knit. We have a lot of fun together.
Chrissy, sounds like she was a cheerleader.
Yes.
Did she do anything else for extracurricular and co-curricular activities?
She danced since she was probably 5.
For how long?
Till she graduated from high school.
Was she a hard worker?
Yeah.
Did she keep jobs?
She did. She helped defray the costs of dance lessons by working and teaching kids in dance studio. She worked in the daycare in Granger. She worked for the marina, Sailorville Marina.
Okay. Did she get positive reviews from people she worked for?
Yes. Pam and Mike Finnested had the Granger daycare, and they also were the hosts for Chrissy and Toby's wedding. And Vern Eden owned the marina in Sailorville, and he told me several times that if everybody worked as hard as Chrissy, he wouldn't have any problems at all.
How would you describe Chrissy's character?
She's the most loving person that I know. She's caring, she's compassionate, she's considerate. She loves Tanner to the ends of the earth. She would do anything for him.
Did she have any enemies growing up?
No.
Did she ever have a rebellious streak growing up?
No.
Did she have a curfew when she lived at home?
We never did that to her because she always respected a good time to be in. 10:30, 11 o'clock, she was home. We didn't need to put a curfew on her.
Now, you lived in a small community, that's
Yes.
correct?
Mm-hmm.
Did you ever hear anything from community members complaining about your daughter or anything along those lines?
No.
Did you ever even have to ground her
No.
while she lived with you? What kind of activities did you enjoy doing with Chrissy?
Well, probably one of the most fun things we did, we both loved the Eagles, and so we would go to Eagles concerts together.
Okay. Anything else?
We enjoyed the day after Thanksgiving, going shopping. We'd plan that whole day out. Back when the Des Moines Register was big, and they had the big day after Thanksgiving newspaper, we'd plan our whole day. My mom would bring down her newspaper so we could have the Yonkers coupon out of there. And we had our delivery, so we had that one, and Chris had run over to the Quick Trip and get another paper. So when it was Annie and Chrissy and myself going shopping, we all had that $10 coupon we could spend.
My understanding is you do not drink any alcohol, is that right?
No,
Your husband, Chris, does not drink any alcohol? Do you know the last time that you've ever seen Chrissy drink any alcohol?
I honestly can't remember.
Okay. Do you know whether Chrissy has ever used any illegal drugs or controlled substances to your knowledge?
No,
Chrissy's son Tanner was born in 2015, is that right?
yes,
Now you, as a mother and a grandmother, had a very unique opportunity to observe Chrissy as a mom over Tanner at a very young age, is that right?
that's right.
Why don't you tell the court about that?
They lost their house in the tornado in Woodward. And so Tanner was 3 months old, and they lived with us along with their 2 dogs, and Jack and Junior. And we had 3 dogs, and we had 2 kitties, and so it was a full house.
How did Chrissy handle being a new mom, being displaced by a natural disaster like that?
She, very calmly, very resilient. She would go to work, she'd come home and she'd work on what she needed to gather for the insurance companies. She'd have to go through room by room and try to remember what was in each room and itemize. I mean, how many bobby pins did you have? I mean, it was just that kind of detailed, but that was what she had to work on for her family to get back home to their home that they were trying to get built.
And as Tanner grew, how would you describe their relationship?
They're pretty tight. Tanner's like Chrissy. He's just a calm, straightforward, compassionate, caring. He will sit and talk, like Mr. Grell said, he'll just sit and talk with you, look you in the eye and have conversations with you. My dad's 100th birthday party last year, I had him meet my high school girlfriends that came from my dad's birthday party, and Tanner was just involved with them, talking to them like he had known them forever. He was interested in what they had to say. Chrissy's the same way, exactly the same way.
Was Chrissy involved in Tanner's activities throughout junior high and high school?
Oh yeah, she never missed anything.
What about fundraisers and things like that? Was she involved in those?
Yep.
Tell the court about that.
They had, the junior class raises money in Woodward for the senior prom, a junior senior prom, and also their senior trip when they become seniors, and the cap and gown. And so she would work the concession stands like other parents would to raise that money for their kids.
Tanner excelled not just athletically but academically as well.
Yeah, he's a member of the National Honor Society.
Was he academic all-conference for baseball and football?
Yes.
Did he receive scholarships coming out of high school?
Yes, he did. Yes, he did.
Who would Tanner attribute a lot of his success to?
Both his parents, both of them.
Is the family structured and responsible?
They are, and Tanner grew up knowing that he needed to be responsible as well.
Now that Tanner's off to school, how has Chrissy's role as a mother changed? Have you seen that?
It was, like any parent sending their child off to college, it was tough to let him go. And Tanner is their whole life. And that void was gone, but I would tell her, it's just a change, and you're going to find a different avenue. You're going to enjoy this next chapter with Tanner going to college, and they have.
Tanner still comes home and visits?
Yes.
Does he bring all his laundry home?
Oh, my. Yeah. the last time he was home, he's smiling at me right now. Last time he was home, he brought, Chrissy was telling me, oh, he brought all his laundry, even all his bedding, Mom. And I said, well, I know you love it, so, that's...
She still enjoys taking care of it,
Yeah,
right?
she does.
Now, one of the requests we made to the court was to potentially appoint a custodian for Chrissy if she were to be released on bond in the community. Would you be willing to serve as a custodian?
Yes.
Which would mean if Chrissy violates the terms and conditions, you would have to report that to the court. Would you be willing to do that?
Yes.
And if necessary, could Chrissy live with you if that
Yes.
were necessary? Okay. Based on you knowing Chrissy her whole life, do you have any reasons or concerns that Chrissy could pose harm to the community if she were released?
No.
Do you think she would flee if
No.
she were released? I know one concern that the state raised in its resistance was she may harm herself. And I feel like you would be in the best position to discuss that and allay those concerns. Would you tell the court, from your perspective, whether that's a legitimate concern?
No, she would never, ever, ever do that to Tanner. She would never leave him. No.
Okay. No other questions?
Cross-examination.
The state has no questions for Ms. Boyles.
Ms. Boyles, you can return to your chair as well. Does that conclude the evidence that the defense wishes to offer in support of the motion?
We would just formally move Exhibit A, which had roughly 70-plus pages of support letters, into the record if that hasn't been accepted yet, Your Honor.
Is there any objection to the exhibit, which is I think it's about 72 pages of support letters from community members on behalf of the defendant? Does the state object?
No, Your Honor.
That exhibit is admitted. Just to confirm again, the state does not intend to offer any evidence, is that correct?
We do not have any witnesses or other evidence to offer. That's correct.
Your Honor, we have a professional statement to make at this time pursuant to what we discussed prior to the hearing starting with regard to...
And this is going to be separate than your argument, is that right, sir?
It will, Judge.
Very well, then go ahead.
Thank you, Your Honor. May it please the court and counsel, Ms. Ramsey is 53. She's been employed for 14 years at the same job at Midland Title Escrow. And I would present this, Your Honor, the record should show, as a professional statement. She's lived in Dallas County her entire life. She has no criminal record, one speeding ticket approximately 15 to 18 years ago. She's never lived out of state. She has few family members living out of state. She has taken vacations. The vacations have been in Florida. One was to visit with her grandfather, who had moved down there at one point, the gentleman who is the war veteran and hero. She and her husband would drive down to visit with them. Her health is good. As a matter of fact, when she was initially interviewed by the sheriff's office, which is a well-run jail, Your Honor, I want to, the gentleman in charge of it has done an outstanding job there. When she was given the sheet, they checked on her. She had no emotional drama to the extent that they felt she needed additional help. They did one interview, then they did an interview approximately 14 days later. She's had no disciplinary issues. As a matter of fact, in the 4 visits that Mr. Brown and I have gone there, and just passing, the staff, which is an excellent staff, indicated she's had no issues there. She indicates she can follow any conditions of the bond that the court would set on her within the parameters of what we will discuss later. All the firearms have been removed from the home. That was directed by our office to have that accomplished if the court were to allow her to go back home with those conditions. She would work if a job became available. And I believe, Judge, that's all the record that we would make at this time, and ask the court to accept that as a professional statement on behalf of, oh, thank you. She has no passport and has never had one.
Very well. Mr. Brown, do you have any questions for Mr. Parrish? Obviously, a professional statement is evidence, and you have the right to cross-examine if you wish.
I just have one point of clarification on employment, if I could.
You may.
Is the job that she had before she was arrested still available to her if she is released?
We don't think so. We've not explored that because we've been busy working on the this matter, but we've not explored that, right?
All right, thank you.
Very well. The court will accept Mr. Parrish's professional statement as evidence, and will consider it as part of the evidence presented here today. We have been going for almost an hour and a half, so I'm going to take a 15-minute recess. When we come back, I'll be hearing the arguments of counsel, starting with the defense, followed by the state. Then again, because the defense is the moving party, I'll give the defense the last word. So we'll be at recess for 15 minutes.
Thank you, Anna.
All rise.
Thank you for the passport. I don't know why it keeps slipping my mind.
In fact, we're just talking about that a bit, so that's great. Let's do that.
Give Kyle's a little, give.
Thank you again. You may be seated. Before we turn to the arguments of the parties on the motion, I had an opportunity to discuss with the parties during our recess, our next proceedings in this case. The parties have agreed and the court will approve the request to set trial for January 11th, 2027. January 11th, 2027. The next hearing I'm going to set in this case is a status conference for June 19th at 1:30, June 19th at 1:30. The court is setting that so I can touch base with the parties, see how the discovery or exchange of information is progressing, and so we can see if there's any further hearings that need to be held. So I will enter an order in writing in the next day or two, reducing that to writing of those future court dates. With that, thank you for your patience, counsel. Mr. Parrish, when you're ready, sir, I'll hear your argument regarding your motion for bond review.
I am ready, Judge. And may it please the court and counsel. Judge, if this is any guidance, I'm going to read from a transcript of proceeding in your courtroom in August of 2020, where there was a contested bond issue. And at one point, you pointed out to both counsel, one was Joe Chris, the other one was Jonathan Cowsey. You said, I would say that ultimately, whether or not these charges hold water will be the responsibility of the jury, not the court, at this stage of the proceedings. I understand that there's a factual dispute between the parties, and I'm not going to resolve that here now. That will be for the jury to resolve. And Judge, that's from a transcript. I gave you the date at a Polk County matter, August 21st of 2020. And Judge, if that's your belief and philosophy, obviously we all change as time moves, but that's a pretty statement as to where we are in terms of this case, because you have seen the pleadings that have shown the incredible fight that we have on the facts. Now, whether or not they developed properly or developed in dispute from our discussions and where we are dealing with a case 15 years old where we all know there are incredible gaps. And from what we've been shown, there is nothing new. Nothing. With that in mind, Judge, I'd like to address briefly the three factors. And I'm not going to dwell on the nature of the offense based upon your statement. The danger to the community, that's been addressed. As a matter of fact, in their cross-examination and in the failure to produce any exhibits or a single witness, and I know the burden's on us by a preponderance, the state has not challenged that to any extent that should cause you to say, well, let's keep the bond where it is. It doesn't work. They would have to establish some way for you to believe we didn't meet our preponderance. The risk of flight, the factors, Judge, that should be considered. She's lived here, Ms. Ramsey lived here her whole life. Her family lives here. Her heart and soul resides in Woodward, Iowa. The trips that she's talked about, being out of state, not having a passport, having a strong familial connection, establishes that she's tied to this community. She has no criminal record, one speeding ticket. That is significant because not only does it show something about her life, but also her character. I will talk briefly, very briefly, about the pleadings filed by the government in this case. Clearly, they're upsetting, but we have to respond to that, and I think we've done a decent job of responding. I will say this, though. One of the most distressing things to me about their pleading was the fact, from earlier discussions, I was led to believe they had clearly acknowledged that Ms. Ramsey had nothing to do with the drugs in the house in 2011 when they had a search warrant, or 2026. If I'm wrong, that's fine. But that's what we were led to believe. I will make a professional statement with regard to that. But if they are now saying that, and the firearms, let me make this statement, which I think is fascinating about the investigation to this matter that goes to the nature of the offense. In 2011, they saw firearms in the home. Did they tell you how many they seized? I'll tell you, 0. 2026, they went to the same home, to the home, and they claimed they saw firearms. How many did they seize? 0. We've told you in our professional statement that we've asked that the firearms be removed from the home. So that deals with this idea, which I think is the most troublesome aspect of the state's case, about this is not a safe home for Ms. Ramsey to go back to. So we believe, Judge, that we've addressed those issues directly, but I was a little concerned, confused, and actually didn't understand their pleading on that issue. But a pleading doesn't make the case. If they thought it was an issue, they could have presented a witness or two, or a professional statement or so, but they can't, and they know they can't. So, Judge, we would ask you to not consider those factors and allow her to be set up. And I think the terms that we have presented, Judge, and I know from our thoughts that you have ideas as to whether or not, let's say, other bond issues that have been issued in Dallas County, Polk County, other county, may not carry significance, but I think we battle that out also in our pleadings, and knowing you as I do, I know you've read it, so you know where that battle is. And I would just point out one factor, Judge, that is more general in terms than what I would call a tit for tat as to who gets out on bond. Those are factors that makes a case unique. What are the factors in this case? Well, one is that it's 15 years old and they've not presented one iota of physical or any other type of evidence to show that anything has changed except the name of the investigators. That's it. But also what is important in this aspect is that we have presented what we believe is a case that shows the first part of her life. And people say, well, character is formed at 5 years, right? That's what we say. That's what we believe. That's why we read our kids their children's books, because we want to impact that character. Well, the state cross-examined Ms. Witt by saying, well, you stopped seeing her. But at 12th grade, Judge, we all know most of the significant characters in a person's life is established. Let's go further. What was the next aspect? A person who lives across the street, and of course their only cross-examination was, well, you only saw her as a neighbor for 17 years? If I don't know my neighbors for 17 years, Judge, and what they're doing and what the car is going back and forth, I don't know much. So I ask you to consider that as a factor. This gentleman who was a principal, who knew people well, who interacted, who talked about Tanner and what he was like, and going to his game and talking to him like he was concerned and involved in the conversation. That's pretty unique, Your Honor. And that becomes because of his mom and his dad. Now, what about the last person, her mother? The father of this great war veteran who's sitting back there, and I went back to talk to him, and I said, you're one of my heroes. My dad was in World War II, but he was stationed in Africa during World War II. And he came to my office, and I said, I just want to take my picture with you and share what you did. And in his comment to me, he said, I said, were you afraid? Were you fearful? He says, only once when I got there, and the day after I left, my fear was no longer there. But I said, I researched you, and I could not believe the feats that you had fighting for France. And he was the same young man, I make that point to say, same person who's sitting back there who she used to go visit in the summer. Ms. Ramsey would go visit in the summer with her husband to keep a relationship with him, and the one who now goes back and forth to his house when she was out because she loves him and he loves her back. So that is significant. It shows the incredibly strong family ties. We put a map in our exhibit, Judge, that shows how these folks live in relationship to each other, all in close contact. Even a friend from high school, they talked about how they still stay in contact. Her gentle nature, how she responds to things, how she reacts, even at the jail, how she has had no disciplinary action over there. It's also important to show a little bit about her character, Your Honor. I'm not going to dwell on a lot of this, and a lot of this, Judge, I think, in terms of bond issues and stuff, this court understands. We did not present Ms. Gentry because obviously she was going to make a professional statement about Golan Park. That's out of Dallas County, but I don't think that's necessary to do. But let's talk, Judge, just briefly in my argument about the strength of the evidence. I will say this, Your Honor. You've tried a lot of cases in Iowa. So have I. In 66 of the 99 counties, I have tried cases. A lot of them first-degree murder cases. And in these murder cases, Your Honor, in state court, this is the first time I've ever walked in where there's a grand jury been assembled. The first time. And when I read the transcript over 2 weekends and read it again, I was stunned. But it doesn't matter whether I'm stunned or not. When I heard the officers say, hey, we've charged somebody, we got a lot of work to do, I was stunned again. And I don't even watch TV that much. It just popped up. So that tells you, Judge, they have problem. When the state tells me, well, this is all we got, this is our entire case. When you read it, Judge, with your experience and with the experience that we have here, we understand there are issues. You don't wait 15 years and then you say, okay, let's make a go of it. But that's not your decision right now. I agree. That's not what you have to decide. What you have to decide, is she going to run? There's just no place to go. She doesn't even have a passport. Is she a danger? 17-year-old neighbor says, no. What does her mom say? No. Is she going to harm herself? No. If there was some evidence of that, Judge, during that evaluation that she had when she first got to the jail, obviously we would be hearing it over and over again, but we don't. Prior criminal record? Absolutely nothing. This person who served as a third-party custodian, actually in federal court, not to say that they do it better, I don't think they do. God, don't quote me on that, but I don't think they do, but they allow third-party custodians. But does she need one? We don't think, Judge, based upon the evidence that's been presented here, her conduct at the jail, her life experiences, her close-knit family, she doesn't need that. She should be able to go to her lawyer's office, plow through this truckload, they called it truckload of evidence that they're going to give us, that they've collected over 15 years, as opposed to sitting in the jail with us visiting 2 or 3 times a week doing that. That's not a factor, but Judge, I think you can consider that, balance that out with who she is, what her life has been like, and the incident. And then one of the most interesting factors, Judge, I found was that, and I don't know, I'll put it in a nice way. We haven't seen all the documents from the grand jury yet, and we're very interested in seeing it. But this grand jury pushed back. You know, this old saying about, well, you can indict a ham sandwich. I know it's hadn't happened in a couple of cases that are around the country right now. But the interesting thing, this grand jury pushed back. And the most fascinating part about the time the grand jury pushed back, these law enforcement officers said stuff that just didn't make any sense. That's what happened. And when you read it, if you probably have read it already, that's part of the strength of the case that you should look at. Judge, no prior criminal record, ties to Iowa. She's willing to stay away from the family. It's not going to be an issue with her being in contact with the Okland family for 15 years. She's done that. If there's a need, I think that's our call or her call, our family calls if she needs to go for any type of mental health examination. She's willing to take a drug test if that's necessary to get it done. They would allow an inspection of the home to go in to see if those weapons are removed, a case I just finished in Adams County. That was one of the requisites that we had. Obviously, you can put it in your order saying no firearms in the home, no drugs in the house, and have an inspection. She can be subject to pretrial release condition. She's willing to do all of that. A bracelet. Do I think you have to go that far? I don't think so, Judge, based upon the evidence that's been presented here. But we are putting those options on the table for you to consider. And let me close with just a couple of matters that are really distressing from what the state did in their pleadings. They claim there was a witness, but they don't acknowledge that one of the witnesses that they claim was practically blind and didn't identify anyone. They claim that they have some type of new evidence, but not one single iota of new forensic evidence was brought to the grand jury's attention. They claim they have a timeline, but yet they had a broken clock, and the person who couldn't see had to punch the clock to make the sound, and the time was off. They claim they have a motive that they tried to hint to through cross-examination, but the motive, I don't even want to say it, but it's pure speculation. They claim they had some physical evidence, it would seem, but no physical evidence. The phone records have not been disclosed yet in this matter. And, Your Honor, let me just say one thing before closing about the strength of the evidence. And your experience in this area, you've done a lot of cases, and so has Mr. Brown and Mr. Schultz. All right, just picture with me 1 second. You have a person, let's say of interest, who's there for an hour or so, and you think they fired a firearm. They would say, well, we don't have all the technical stuff out there that we used to have. But what's the old-fashioned way, Judge? 15 years ago, you did an antimony and barium test. That was so simple. They didn't even do that. And they take reports and they have new people look at it and say, this is good enough to pass muster. So we use those, Judge, and I know you've indicated in your prior ruling and your philosophy, at least, that the fights that we have going on and will be going on for a while is not something you have to decide. But the evidence otherwise, Judge, we've met the preponderance. The state, you can only consider that cross-examination questions. They were weak at best. And we believe that we've addressed the ones that we thought had been resolved because they knew better. Now, maybe they're going to tell you something different right now. But when we started this case, that's not where it was. And you didn't hear one person come up and say, they've seen her with drugs, they've seen her with firearms, we found this bullet somewhere. Judge, we asked for a reasonable bond. That's all we were asking for. So she can prepare to defend herself. And do it while she's out with a family who loves her and who she loves back. This is a unique case. It is a unique case. And we're asking you, Judge, to follow the evidence that was presented during the bond issue and give us a fair bond. That's all we want today. Thank you, Judge.
Thank you, counsel. Next, I'll hear from the state.
Thank you, Judge. The state's position here is that the bond set currently in the amount of $2 million, cash only, be maintained. There are a number of considerations that the court can take into account that involve the totality of the case, involving the minutes of the grand jury, the minutes of testimony that have been filed, and considering all the facts and circumstances in this case. There's a whole laundry list of considerations the court takes into account pursuant to Iowa Code Chapter 811.1, subparagraph 2, I believe is the correct citation. Basically, what the court is looking at in terms of all those factors relates to making a determination sort of as to the future. Is there a reasonable assurance the defendant is going to appear at all the court proceedings, that she'll do what she's required to do? Is her release, or does her release constitute, or will there be a consideration that it would jeopardize the personal safety of her or another person or persons? Chief among those considerations that the court has to take into account are the nature and circumstances of the offense. I find it interesting that the defense argues here, well, that's not that important, and then goes through and tells you how bad our case is. Without having done any discovery in this case, there's been no motion for discovery. They haven't looked at our complete file. They've not asked to look at our complete file. We have an open discovery policy. They know that. Yet throughout this argument today and through the pleadings that we've seen from the defense, they seem to make it sound like we're keeping things from them or stating things that they're never going to have, which is not the case. So let's look at the nature and circumstances of this. It's the first consideration the court makes in the laundry list of things that's in Chapter 811. This is a Class A felony. The defendant is facing a life sentence without the possibility of parole if she is convicted. The nature of the charge in and of itself creates a situation where a defendant is more likely to flee. Once she understands the nature of the case against her, which includes the evidence in the, not only that was presented to the grand jury, and all the evidence, by the way, presented to the grand jury is part of the investigative file. But once she's faced with that, in our estimation, it makes her more likely to flee. It also potentially puts other persons in danger. Her life is different now. It was several weeks ago, she's not charged with Class A felony. Now she is. That changes any person's circumstances. She has had access to weapons in the past. There's no assurance the defense can give us that she will not continue to have access to weapons. I don't think there's anything they could really say that would keep us or would provide an assurance to the court in particular that she would not have access to weapons. Concerning the circumstances of this offense, Mr. Parrish has spent some time here this afternoon assailing the investigation and what has been done that needs to be addressed. I'm not going to go through all the details. I'll address the matters that he raised, but this case has been thoroughly investigated. This was not a case that where our investigators said, hey, let's look at this case, and then the next day we were filing it. There's been a considerable amount of time, effort, and energy that has been put into this case over a number of months that they've been working on it. Leads that the defense raises in the pleading they filed yesterday concerning other potential suspects, those leads have been exhausted. The defendant, there was a reference that she had gone to get help from a colleague. That's not accurate. She did leave the scene after the shooting happened. As she returned, there was about a 15-minute period where that happened. The defense has raised the lack of physical evidence like DNA, blood spatter, gunshot residue, that even if those things did exist, they would really have no significant bearing on the investigation. The gunshot residue, I find it interesting that they raised that one in particular. Our laboratory at the DCI has not done gunshot residue testing for 15 plus years because of the lack of reliability of gunshot residue testing. So anyway, given those things, I mean, I agree with Mr. Parrish in the sense that, yeah, this will all come out at some point, but the facts, the nature of the case, the nature of the crime, and the circumstances are factors that the court has to consider. Again, Judge, under the circumstances of this case, given what sentence that is facing the defendant if she is convicted, you have all of the details. There is a front-end timeline to this offense that occurred. It's 1:56 p.m. It has to do with an email that Ashley Okland sent. It was unrelated to the homicide, other than she was making plans for that night. And then there's a 911 call that is made on the back end of it. That's a very tight timeline. Given that in conjunction with the witness who observed Kristin Ramsey in the area, her statements that she made to police, which can only best be described as inconsistent, are such that the nature of this case, the circumstances of this case, demand a higher bond, and that's where we would ask that the court place that. It was set initially at $2 million cash only, and we would ask that it remain there. Thank you.
Mr. Brown, I have not made any decision, but I want to have the benefit of full information. Should I decide to change conditions of release and lower bond, I obviously have the ability to add other conditions of release. Are there any that the state would be requesting?
Judge, if under any circumstances, if the defendant is released under any conditions, even if she were able to post a $1 million or multi-million-dollar cash bond, we would ask that she be placed under the supervision of the Department of Correctional Services. We ask that she be placed on an ankle monitor and put under the most restriction the court would be allowed. There may be other conditions I'm not thinking of at the moment. I know there's been a history, at least with one other defendant, where she was placed under house arrest. I think that was a reference that was made in another case I did with Ms. Gentry. And if that restriction were available to the court, we would ask that be imposed as well. But we would ask for for lack of a better term, the tightest restrictions the court could place upon her should she post any bond, including a cash bond.
Thank you, counsel. Mr. Parrish, sir, again, since it's your motion, I'll give you the last word.
Thank you, Your Honor. I think Mr. Brown's going to do that if that's okay with the court.
Of course. Go ahead, Mr. Brown.
Thank you, Your Honor.
Thank you, Your Honor. May it please the court. It sounds like the state is primarily relying on the nature and circumstances of the offense. And then to support that, they want to turn the court's attention to the minutes of testimony, which are the grand jury transcripts. But we want to remind the court to not put as much weight and emphasis on those minutes and those transcripts as the state wants, because under the rules of criminal procedure, that same book that the state held up at the beginning of this proceeding and relied on does not require the state of Iowa to allow us to present any evidence on behalf of Chrissy at that time. And furthermore, those grand jury rules that they rely on require no evidence of mitigation or no exculpatory evidence be presented during the grand jury testimony. So essentially, all of these hundreds or thousands of leads they received, none of that was presented. All of the potential exculpatory evidence that is included in a file that we, for the very first time here, heard that there's an open file policy when just Moments ago, we were back in chambers, and we were told that it would not be disclosed because it doesn't want to be done in a piecemeal fashion, was available to us. So we're a little bit concerned about some of the statements that are being made here today to the court on the nature and the circumstances. When we don't have a lot of this stuff, the court hasn't seen the exculpatory evidence, and we believe there is exculpatory evidence in there because of past press statements that were made at the time of the offense, leads that were explored, that were never presented. So again, when we're talking about the nature and circumstances and relying on the testimony and the transcripts, be cautious, be careful, because we haven't had our turn yet. And we are waiting for the discovery, and we will defend this case on the nature and the circumstances. Now, also, in terms of there's no assurance that can be given to the court on flight or things like that, Judge, or access to guns, which is what we heard in the state's argument. I mean, the court can give assurances, and they're called court orders. If there is a situation, take it out of the context of this case, there's a dispute between two married folk. There is a no contact order that is entered. That no contact order gives assurance that somebody's going to be protected, that gives assurance that somebody's not going to be within the vicinity of that person. That same kind of assurance can be given in this case through a court order, preventing Chrissy from having access to firearms, to anything else that the court is concerned about. So absolutely, the court can give assurances to the community that Chrissy doesn't pose a risk of harm because the court has directed her to. And there's contempt for that. And there's revocation of bond and all of those consequences that would be available. So yes, this court absolutely can give assurances to the public. Now, I'm not going to belabor the other factors because they overwhelmingly support a drastic reduction in bond in this case. The state focused on one or two, but we have family ties. We have seamless employment over Chrissy's entire life. We have her character. We have discussed there's no mental health issues. There is a lifetime length of residency in the community. There's no record of convictions, sans a speeding ticket. There's been no issue with court appearances because she's never been in trouble before. All of these factors, Your Honor, support that dramatic reduction in bond. Now, I know every case is different, but the prosecutors did cite to two cases out of Dallas County where the defendants, I believe, started out with a $1 million bond. One of those cases, I'm not sure if a bond review was even asked. In the other case, the defendant had a pretty significant criminal history that the state relied on for the $1 million bond to remain where it was. And if those are $1 million bonds in those cases, we feel like that should be the ceiling where the court starts considering this case and go down from there. And if you look at all of those factors, they do support what we're asking, which is a $100,000 bond. We would be able to post an unsecured 10% of that amount to the clerk of court. We would agree to electronic monitoring. We would agree to a curfew. We would agree to being appointed a pretrial release officer with the Department of Correctional Services or any other designee that the court deems appropriate. You heard unequivocally the evidence in this case, including over 70 pages of community support. You heard from witnesses who Chrissy is. Her character since she was a child until now has been unwavered. There's no evidence that there is anything different in who she is now and it is against who she was then. That's why we're asking that the bond be reduced to the request that we made.
Thank you, counsel. Well, I want to end where I began by acknowledging that I understand that the outcome of this hearing is important to all concerned. I have an important responsibility to make a determination of the motions that are pending before the court. And just so the parties know and the people here watching know, the court has discretion in this proceeding. But my discretion is just not unlimited. It's not my whim. There are certain factors that I have to decide and have to consider, including the law, a number of characteristics of the defendant, a number of factors. I've heard evidence today, and I've heard arguments of counsel, and I want to take some time to consider those arguments, to look at the evidence more clearly, again, in light of what I've heard here today, so I can make the best decision I can on what I've heard and what will, in this case, be a suitable bond, whether or not the bond should be modified. In making my determination, it's important the public know that a bond is not meant to punish somebody. The defendant is presumed innocent. On the flip side, there's been a finding of probable cause that the defendant committed a very serious crime. The court will have to give thought to what I've heard, and I intend to issue a ruling in writing. I'm hopeful by the middle of next week at the latest. I want to close by saying to counsel that I appreciate your efforts today, representing your respective positions. You've given me a lot to think about, and I appreciate your advocacy, because in order for me to make the best decision I can, it's incumbent upon me to hear from both sides putting forth their best arguments. So thank you for that. Hopefully that will sharpen my decision making. I also want to close by thanking the members of the community or interested party who came here today to watch. Your behavior lived up to what I expected. This is an important matter. It needs to be conducted with dignity, and you've lived up to that, so thank you very much. With that, we are adjourned.